me, unusually coming into this as an outsider, the strange thing about, estate planning is that it kind of seems like it's exactly the same solution. Doesn't matter how, whether you've got $1 million in the bank, 45 different properties. It seems like it doesn't matter whether your job title is the owner of the business or, you're the newest recruit in the business. It fundamentally seems like exactly the same approach. No matter, what your wealth level is, what your asset level is, what age you are, what your title is, it seems like exactly the same approach. Is that wrong or is that right?
No, that's a great observation. It doesn't matter what your title is in the business. If you've met that $100,000 threshold in one way or another, the solution is going to be very similar for each person. At the end of the day, the package that we offer is the solution for everybody. The work that we might end up doing, depending on what your assets are, could be a little different because we might need to fund more real properties. You might have additional assets, stocks, bonds that we would work with you to fund. But generally speaking, our average package is going to be the same for the CEO as it would be for the marketing team, as it would be for the HR team and the engineering team, and everybody in between.
So again, as you say, it doesn't matter which team you work in, what your job title is, what are the simple steps that takes you from having no estate plan to having a fully completed estate plan?
Yeah, we've made this process very easy for everybody. So the first step is to go ahead and do the free consultation. After that consultation, if you decide you'd like to move forward, from there we do an asset analysis. Once the asset analysis is complete and we have all of the data that we need to finalize your estate plan, we go ahead and get those documents prepared for you. We do a final approval with you all, and once that's complete, a mobile notary will come out to your home, or you can set it up online depending on the laws in the state that you reside in. And once the signing process is complete, your estate is in full effect.
So the consultation is like 30 minutes to 60 minutes up front?
Yeah.
Secondly, for them to complete the asset register, how long does that take?
Typically, the asset analysis is going to take anywhere from 60 minutes up to 2 hours. That's going to depend on the amount of assets and accounts and your overall estate, though.
And then with that information, the next stage is you go away and create the documents. And how long does that take approximately?
Typically, the turnaround time on that will be roughly 5 business days.
So then the documents are sent to the client. They then review them. Come back with any changes. I'm guessing sometimes it's a bit back and forth. And
yes.
Then once that's done, then it needs to get signed. Is that right?
That's correct. Once we receive the final approval from the client, we streamline the signing process. It's very complicated to orchestrate a notarization for these type of documents. This whole packet will range from anywhere from probably 150 up to 250 documents total. This isn't something you would want to go to a bank and ask them to just notarize for you unscheduled. So we take over that piece. We organize the mobile notary. They come directly to your home or where you'd like for them to meet you. We can also include witnesses with our notary services if you need that. Or you can sign the documents online with an online notary, depending on your laws in the state you reside.
Wow, it seems pretty fast. I know. I mean, I think the whole fear of like taking these documents to a bank and someone randomly to notarize them, even just getting the documents, printing them, all these things sounds complicated. But having a mobile notary sounds fantastic, or doing it online, is increasingly the way the world's going to go anyway, I'm sure. But state by state, the laws are different. You've done the interview to see if people want to proceed with you. You've captured the initial information. You've created the documents. You've got them signed. And then if people need to make changes after that.
Yeah, so that was one of our biggest concerns on how we could continue to support our community and protect the families, not just the first time they needed an estate, but also as their lives change. People get divorced, people become widows, people want to disinherit people. There are life events that happen that should trigger an examination of your estate. So what we've done is we've actually set up a subscription service where you pay a monthly fee and you will get unlimited access to edits for the remainder of your lifetime. So when you have a new child, or maybe you have grandkids, or perhaps you've suffered a loss and you need to make some changes, or you need to put a contingent beneficiary as a primary beneficiary because of the loss of somebody.
So you regularly talk about pour-over wills, and I think I understand the concept broadly, but can you talk about exactly what a pour-over will is at a high level, and then really what it means, on a day-to-day basis?
So a pour-over will actually accompanies a trust. So if you have a trust, generally speaking, you will have a pour-over will. And what that pour-over will does is it serves as a blanket coverage over the trust. The pour-over will basically tells the people to follow the trust. And if any assets get left out of the trust after they've established the trust, that pour-over will serves as a document to pour over any other assets or any other properties that you owned at the time of your death that may have gotten left out of the trust.
It's easy to get stuck in the kind of terminology, but the power of attorney is one of these recurring phrases that comes up again and again. What does it mean?
Yes, power of attorney is very, very powerful document. Those type of documents are so powerful that you can actually consider having a clause in there so that the document doesn't take effect until you're incapacitated. So it may make sense for parties to allow somebody to have a power of attorney to act on their behalf prior to their incapacitation. But for most folks, it makes sense for them to have what's called a springing power within their power of attorney, which means that the only time that document becomes effective is when the party is incapacitated. And upon re-entering capacity, that document loses its effect again. It will take effect again if there's another event of incapacity. So
it's kind of like if the president's going in for an operation, the vice president automatically gets the power.
Right.
Once he comes into the operation,
it has to happen for her to have that, right?
Yeah. Exactly.
Yes, exactly. And so that's a very powerful document. It can give you access to your anybody's bank accounts. It can give that party access to sell things on your behalf, to make real property decisions, to enter into business agreements, to run your business. So it's a very effective tool for couples and spouses and very trusted people in your life. And it's really not something that we recommend giving out to just anybody. You have to be very mindful of who that power goes to and how it becomes effective.
And is there only like one power of attorney? Is that kind of, or is it a blanket term that could cover multiple different scenarios, different variations? Is there a different? I guess, are there different kinds of powers of attorney? Or is it?
There are, yeah. There's general powers of attorney. There's medical powers of attorney. There's powers of attorney over minors. There's business power of attorney. So, for example, I have some clients that live in Colorado, own a business in Arkansas. One of them travels frequently, and the other is constantly purchasing properties on behalf of the business, but they're 50-50 partners. So they kept running into this issue where one partner's signature was constantly needed. And so we consulted with them and we were able to get them business power of attorney. But basically the business power of attorney shielded those parties' ability to make personal decisions on these people's behalf and only covered their decision-making processes in regard to the business itself.
Okay, so you can't isolate it. So it's not, so one power of attorney is not a kind of a single document, multiple variations. But when it comes to a will, or an estate plan, is it typically just one broad structure, or does everyone vary it?
Yeah, so our package includes the general power of attorney, and those are typically going to be designed for your husbands and wives, wives and wives, husbands, couples, however they define themselves. Those parties are generally the people that you would want to give that power to, perhaps a parent, perhaps a child as you're getting older. You know, my aunt has a power of attorney for my grandmother. She's 84 years old and she trusts her and she is the responsible one. So she got that power. But, you know, grandma didn't want other people having that power of attorney. She was mindful of who she gave that to for a reason. So very powerful document. The one that we have included in our package is specifically for general power of attorney. If you own businesses, if you have business partners, if you have other power of attorney needs, you can definitely mention that to us, and we can certainly discuss that need and work through that together.
And that would be covered in the sort of the upfront free consultation.
Yeah, just mention it in the consultation, or it may even come up during the analysis, during the asset analysis. As I start asking these questions of, do you own an LLC? Do you own a corporation? It may naturally just come up.